Most of us buy things almost daily. We're constantly making judgments about the value of products and services. Consciously or unconsciously, we trade off price against convenience, quality, service, and selection. Some purchases we agonize over. Most we evaluate quickly and rationally, and a few we make on impulse. What we'd like to do on this tape is to discuss the types of sales practices that cause more than their share of problems and explain some concepts that sometimes confuse people. Judge Wapner will start with a discussion of mail order sales, then door-to-door selling and telephone solicitations. Then we'll talk about guarantees, dangerous products, billing errors, and the fine art of effective complaining. Unless you've been out of the country for the last 10 or 20 years, you're probably well aware that buying by mail has become very, very popular. With more of us than ever before working outside the home, it's hard to fit shopping time into our schedules. Many of us dislike shopping malls, crowds, and traffic. Credit cards and 800 numbers have made ordering through catalogs quicker and easier. Computer technology helps sellers prepare catalogs, build and maintain mailing lists, and ship orders quickly.
Few of us would disagree that buying by mail is now more familiar, more efficient, and less troublesome than it used to be. Yet because so many of us are making so many mail order purchases today, the chances are that sooner or later you will encounter a problem. You can minimize these problems and have a better chance of resolving any that do occur if you know your legal rights. I'm going to give you some basic rules that I want you to keep in mind.
Can I help you?
I have a delivery for you, Mrs. Watson. That'll be $37.50.
I don't remember ordering anything.
Well, ma'am, your name is right here. It's COD. I can take cash or a check. If you don't mind, I'm in a hurry.
Well, all right. I must have just forgotten it. Wait here, I'll get my purse. I just can't understand. I didn't order anything.
That's rule number 1. You don't have to pay for or even return unordered merchandise. Sending unordered merchandise is illegal, except for free samples or those inexpensive items charities send to encourage donations. You're free to consider anything else you receive that you didn't order as a gift. The second rule to remember is, if you do order merchandise, you should receive it within 30 days of your order. The only exceptions to this are when another time period for delivery was advertised or the company notified you after you ordered that there would be a delay. If you receive your order late, you have the right to refuse it. But if you keep it, you have to pay for it. If you are notified that a shipment will be delayed, you have a right to cancel or modify your order. When you do nothing, it means that you have accepted the delay. Rule number 3 is, you are liable for the cost of the merchandise if you belong to a club and don't return the mailing in time. A club in this instance refers to a, quote, buying club, unquote. These clubs usually sell items like books, tapes, or CDs and require you to pay for the items they send out if you fail to respond to their mailing. Before an item is sent out, the club will send you a notice describing the upcoming offer. If you don't respond by the date given on the notice that you don't want the item, the club will automatically ship it to you and expect you to pay for it. The law says these clubs must give you at least 10 days to respond, or you can return the items they send you. Some of these clubs may let you return unwanted items if you write a polite, explanatory letter. They do this because it builds good customer relations. They want to keep you as a member. But remember, if you don't want the item, it's always better to respond in writing to the initial notice and keep a copy of the notice and your written reply. Of course, you may return any goods that aren't what you ordered or that don't conform to the catalog description. Most reputable mail order sellers offer strong guarantees because they have learned that it's less expensive to accept return goods than to lose unhappy customers. And here are some additional tips to follow when shopping by mail.
Be sure to consider shipping and handling charges when comparing prices. Some mail order companies add pretty hefty fees. They can make the real price of the merchandise much higher than the amount listed in the catalog.
If you're ordering from a company for the first time, you might want to make your order a small one. That way you'll be able to judge the quality of its goods and services without investing much money. It might be hard to recover your money if it turns out to be a fly-by-night business in another state.
Consider using a credit card to pay for your order. Federal law gives you the right to dispute credit card billing errors, and you may be able to have your bill erased if the company fails to deliver as promised. The credit card company will become your advocate.
Keep track of what you order, who you order it from, and when you order. You'd be surprised how many people order an item they've seen on television by calling the 800 number and then can't remember the name of the company, the price of the product, or even when they placed their order.
Check any merchandise as soon as you receive it, and notify the company immediately of errors or breakage. Reputable companies will include instructions you can follow to simplify returns. Finally, remember that prices and products that seem too good to be true probably are.
Most of the better-known catalog companies are well established and go out of their way to assure customer satisfaction. But if you do have a problem with a mail order company, what should you do?
If the company can't or won't give you the satisfaction you think you've got coming, you can always take it to court. But you may also want to notify your state's Consumer Protection Agency, which is usually a part of the Attorney General's office. You might want to send a copy of your notification letter to the Federal Trade Commission as well. While the FTC won't respond to individual complaints, it may investigate a pattern of business practices that violate consumer protection laws. And if you suspect intentional fraud, you should also contact the U.S. Postal Inspector. Mail fraud is a federal crime, and the Postal Inspector's office investigates thousands of charges of mail fraud every year. Your local post office can tell you how to get in touch with the Postal Inspector for your area.
One of the oldest methods of selling merchandise or services is door-to-door. Door-to-door selling isn't as popular today as it used to be. For many products, in-home parties are now the standard sales method. For others, catalogs, direct mail, and telephone sales have taken over. One reason may be that we live in a much more dangerous society today than did previous generations. Two more reasons for the decline in door-to-door selling are local licensing requirements and the 3-day right to cancel rule of the FTC.
The FTC rule says that you, the buyer, have until midnight of the third business day after the sale to cancel the agreement by signing and mailing the cancellation form the salesperson must give you. You don't have to give any reason for changing your mind. Remember that. The rule is meant to minimize high-pressure sales tactics to reflect on your decision. That's why it's often called a cooling off period. But even with a 3-day right to cancel, it's always a better idea to wait and reflect on any purchase before you sign a contract. While the rule is widely known among consumers, not everyone knows that the rule doesn't apply to all home sales. Furthermore, it can apply to sales made in places other than your home. The rule covers sales agreements made anywhere other than the seller's normal place of business. It applies to consumer product parties given in private homes and to sales conducted out of rented hotel rooms or at exhibition halls. It also applies if you invite a seller to your home or meet at a restaurant. What it doesn't apply to are some important categories of sales, such as real estate, insurance or security, emergency home repairs, amounts under $25, or sales made totally by mail or telephone.
Telephone selling is also an area of potential abuse.
Telephone selling is now the favored tool of scam artists, although it is also used by many very reputable businesses. Personally, I never buy anything from someone who calls over the phone. I just say thank you and hang up.
Hello.
Is this Mr. John W. Smith?
Yes.
Congratulations, Mr. Smith. I have some wonderful news. According to our credit card list, your Visa card number is a winner. If our list is correct, you have won all of these fabulous gifts. A 10-day Hawaiian vacation for two, including airfare from anywhere in the continental U.S., $1,000 in spending money, and a video camera to record your dream trip.
Really? Wow, that sounds great.
No kidding. All we need, Mr. Smith, is your Visa number and expiration date to check against our winners list. Do you have your card handy?
I thought you said my number 1. Don't you already have my number there?
Of course I do. But I have no proof you're the person this card is issued to. If you just give me your number, I can verify your identity.
Oh, well, that makes sense. Let me get my card. Just hang on a minute, will you?
If Mr. Smith gives out his card number and expiration date, it's safe to say he won't get the vacation, but he will get a hefty amount billed on his next statement. Never give a credit card number to anyone over the phone unless you are the one who placed the call. I can't stress that enough. If you give a stranger your card number, you will have no control over how it's used or who uses it. You may not have to pay for the unauthorized use, but straightening out your account may take months. In the meantime, your credit limit may be severely restricted.
Investment calls are a popular version of the telephone scam.
It is beyond me how these telephone scams continue. When it comes to investment calls, is there anyone who hasn't heard 100 times that if a deal sounds too good to be true, it probably is? Unfortunately, the real problem isn't gullibility. It's greed and laziness. Unless you're tempted by the prospect of a quick killing, you won't be interested when a swindler calls. Unless you're too lazy to investigate the opportunity properly, you won't actually go forward. You have to be both greedy and lazy. The well-meaning pamphlets and consumer alerts published by the government agencies aren't as blunt as this. They don't want to offend anyone, but they do contain sound advice for responding to investment opportunities. Here are 3 main points.
First, never make an investment that's been recommended to you by a stranger's phone call.
Think about it for a minute. Why would the caller be willing to share this ground floor opportunity or chance of a lifetime with you? Be skeptical of printed material, too. A fancy brochure by itself doesn't make an investment legitimate. When you have money to invest, it's always a good idea to deal with people you know and trust, who have good reputations in your community.
Second, never make an investment when you don't fully understand all of the terms of the deal.
For instance, do you know what future contracts are or what affects their price? Do you know who may have a prior claim on the money you invest? Can you liquidate your investment quickly? Boiler room pitches usually follow the headlines, whether they involve grain prices and drought, oil shortages, collectibles, or precious metals like silver, gold, and platinum. Scam artists are very creative in matching their opportunities to current events. When it comes to investments, a little knowledge really is dangerous and expensive, too.
The third rule for responding to telephone investment sales calls: take your time.
Scam artists usually want their money immediately, and they always have a reason why you need to make a decision right away. Of course, the real reason is that they know that if you take some time to think about it, do a little research, and talk it over with family, friends, or advisors, you'll have the good sense to say no. Give the same consideration and care to investing in securities and commodities that you would to purchasing a car or a home. Hasty investment decisions are often poor decisions, and they can leave you poorer as well. Maybe the old saying should be changed to read, quote, invest in haste, repent at leisure, end quote. If you are tempted by an investment opportunity, I have some questions that you should ask. They may help separate legitimate offers from the scams and swindles.
I'd like to see some literature about the company offering the investment. Can you send me something and then I'll get back to you?
Many con artists don't have any literature or won't bother to send it, even if they say they will. Sometimes they say there isn't enough time because the deal is almost closed to new investors. Don't you believe it? Legitimate companies have literature to send you.
What you've told me is very interesting. Will you please mail me a prospectus on your offer?
Many scams won't send you a formal offer because using the post office opens them to federal mail fraud charges. It also gives you some time to think about the offer. And thought is one of the con artist's greatest enemies.
I'm excited by what you're telling me. I'd like to visit your company's office. Can you give me the address and a good time to stop by? Maybe you can give me a tour.
Boiler room operators usually place their calls from out of state. And even if the call is local, they won't want you to see their temporary quarters. They are usually smoke-filled rooms with wall-to-wall banks of telephones. They're staffed by cynical, fast-talking salespeople sitting at long tables separated by short, soundproof partitions. Even if the company they're pitching does exist, the salesman hasn't ever seen it.
Could you tell me a little more about the procedures and fees that are involved if I decide to sell my investment?
The con artist wants you to think only of profits. They'll probably tell you that the costs of liquidating your investment will be next to nothing when compared to the big returns that you are going to make.
Before I do business with you, would you run the proposal past my attorney? He or my accountant look over all my investments. I can give you his number.
I promise you the con artist won't do it. Instead, he will probably make some snide comment about how you should make your own investment decisions. That's a very good sign that it's time to hang up the telephone.
Tell me, which government agencies regulate your company and this type of investment?
Swindlers don't want federal investigators to hear about them. If they think you'll be checking up on them, the salesperson will hang up on you and try an easier mark.
At this point, let's move from discussing sales methods that cause more than their share of problems to something we often weigh too lightly when making a purchase, and that's the guarantee. In law, this is called a warranty. To evaluate a warranty, you need to know just a little bit about warranty law.
There are both federal and state laws that apply to warranties. At the federal level, there's the Magnuson-Moss Warranty Act. This law doesn't require manufacturers to issue warranties on their products. It does stipulate that if there is a warranty, it must be easy to read and understand. No legalese, just ordinary language, and every term and condition of the warranty must be spelled out in writing. The Magnuson-Moss Act also creates two types of warranties, full and limited. I want to be sure you know the difference between them. The label full on a warranty means that a defective product will be fixed or replaced free of charge and within a reasonable time. This includes removal and reinstallation if necessary. With a full warranty, you cannot be required to do anything unreasonable to get warranty service. For example, you cannot be asked to ship a piano back to the factory. This type of warranty is good for anyone who owns the product during the warranty period. If you buy a product second-hand and it's still under full warranty, you are protected just as the original owner was. If a product covered by a full warranty cannot be fixed, or hasn't been after a reasonable number of tries, you should get your choice of a new item or your money back. One word of warning: always check which parts the warranty covers. A full warranty doesn't have to cover the whole product. It may cover only one part, such as the picture tube of a TV. Anything less than the full warranty requirements means you have a limited warranty. A limited warranty may cover only parts, but not labor, or it may allow only a prorated refund or credit. It can require you to return a heavy product to the store or manufacturer for service, like that piano I mentioned earlier. Also, a limited warranty may cover only the initial buyer, and if you're the second owner, you can be charged a handling fee for getting service. Sometimes you will find a full warranty on part of the product and a limited warranty on the rest. It's up to you to read the warranty to see what kind of coverage it offers. The Magnuson-Moss Warranty Act generally requires manufacturers to make a copy of their warranties available for you to look at before you buy. This allows you to comparison shop and get the best warranty coverage available. Another kind of warranty you may have heard about is called an implied warranty. These are warranties created by state law, not by the company. The most common implied warranty is that the product you buy is fit for the ordinary use for which it was intended. That means that an electric mixer has to mix and an ice crusher has to crush. If it does not, you have a legal right to get your money back, to an exchange, or to have the product repaired. Implied warranties come automatically with the sale of a product, even though they may not be in writing.
I bought a new stereo that didn't work properly when I set it up at home. I notified the store and told them I wanted a refund. They offered to replace the stereo but refused to give me my money back. Don't I have a right to the refund?
Not necessarily. Depending upon the state, if the merchandise you buy is defective, the seller has the right to try to fix the defect by repairing the item or replacing it with an identical item that properly works. If the seller isn't able to do this within a reasonable amount of time, then you have a right to a full refund.
I bought a camera from a department store and it was marked as is. When I got home, I noticed the lens was cracked. What are my rights?
In most states, when a product is marked as is, it is assumed that the buyer took the chance of getting damaged goods in exchange for paying a lower price. Therefore, you would have no right to a refund or an exchange. This generally applies to purchases between private consumers. For example, if you bought a lawnmower at your neighbor's garage sale and later found it didn't work as well as you had hoped, your neighbor would not be required to refund your money.
I bought a pair of sweatpants at a discount store. The next day, I realized that they were ripped. When I went back to the store, the manager pointed to a sign that read, "No returns, no refunds." If I sue the store in small claims court, am I likely to win?
A court would need more facts to determine the outcome. Normally, when a store displays a no refund, no return sign, it is assumed that a purchaser has been alerted to the possibility that the product may be irregular or damaged. The purchaser then has the responsibility to carefully inspect the goods before he purchases them. A court may enforce your right to a refund if the no refund sign was in very small letters or in a spot where it was difficult to read. In this case, the average person may not have been able to read the sign and thus may not have been alerted to the store's policy. If you do go to small claims court, make sure you bring a picture of the sign and where it was located. The no refund, no return signs will not protect the store owner if the merchandise sold by the store owner to the consumer was defective. Whenever you make a purchase, especially a major one, it is a very good idea to read the warranty before you buy. Make sure any verbal promises by the sales representative are included in the written warranty, since that is what will govern if there are any problems. Keep your sales slip with your warranty, since you may need it to prove the date you bought the product or that you are the original purchaser. Getting a good warranty when you make a purchase can protect you against a big repair bill later on.
I bought some expensive caviar at the supermarket. When I got home and opened the can, I found that it was spoiled. When I took it back to the supermarket for a refund, they told me to contact the supplier. The supplier then told me to return it to the store. Who is responsible?
You have the right to expect that the food you purchase from a supermarket is fresh. The supermarket is normally obligated to give you your money back or exchange your purchase for an unspoiled portion of the same weight and quality.
I bought a microwave oven from a local store. After numerous problems with the oven and while it was still under warranty, I tried to return it. Unfortunately, the store went out of business. What can I do?
Your warranty was probably provided by the oven's manufacturer. Contact them about the repairs.
What about so-called extended warranties or service contracts? They're offered on big-ticket items like cars and appliances. Are they a good investment?
That depends. In many cases, these contracts really don't provide much coverage for all the money that they cost. In fact, you may find that the things that are most likely to go wrong with an item are excluded from coverage. Some of these extended warranties require you to perform maintenance procedures that aren't really necessary. If you don't follow the manufacturer's maintenance guidelines, you will find that your coverage is voided if a problem occurs. And there may also be big deductibles that you will have to pay before the service contract's coverage kicks in. I would recommend that you think long and hard before you buy a service contract on any product, at least not until you've satisfied yourself as to the extent of the coverage.
This is a good time to talk about products that turn out to be dangerous, like a coffee maker that catches fire or a hair dryer that gives you an electric shock. If you or someone in your family is injured by any kind of product and you think the product is unsafe, you should contact the Consumer Product Safety Commission in Washington, D.C. Its current toll-free number is 800-638-2772. You'll also want to call this number to get general information on many products that the Consumer Product Safety Commission has investigated or is currently testing. Defective products cause a lot of injuries that should be reported and aren't, often because the consumer thinks the accident was his own fault. Be safe instead of sorry. Report any defect that causes harm. Any reputable manufacturer will want to know.
If the product causes a serious injury or significant damage, you should probably contact a lawyer as well. The law is most favorable to the buyers and users of products, and the contingency fee system we talked about on the first cassette helps seriously injured people get a lawyer to help recover their losses. It is true that years ago it was pretty difficult for a consumer to successfully sue a manufacturer or a seller over a defective product. That is because sellers were protected by a legal doctrine called caveat emptor. Literally translated, it means let the buyer beware. Caveat emptor made the buyer responsible for inspecting a purchase and assuring that it was without defect before buying it. That rule made some sense when goods were simple and people didn't buy very much. Today, it isn't strong enough and has been replaced by the doctrine of strict liability. This doctrine makes both the manufacturer and seller of a defective or unsafe product liable for the foreseeable harm the product causes. There is no responsibility on the part of the injured person to prove that someone was at fault. Another doctrine that used to protect manufacturers is privity, which meant that an injured person could only sue the person he purchased the product from, usually a retailer. It was then up to the retailer to turn around and sue the manufacturer. Today, the doctrine of privity no longer applies to consumer transactions. A person who buys a defective product and is injured because of it can almost always bring a lawsuit directly against the manufacturer. The law's definition of a defect is broader than you might think when a product causes an injury. It includes manufacturing defects such as loose or missing parts, or a short circuit, or design defects. One famous example of a design defect was the gas tank on early models of the Ford Pinto. As originally designed, the tank on the Pinto was vulnerable in rear-end collisions and had a tendency to explode on impact. The attorneys who sued Ford claimed that the company knew of the dangers associated with the gas tank and did not take adequate steps to correct the problem or warn the public. The attorneys found that Ford made a cost-benefit calculation and determined that it would cost more to correct the gas tank problem than to pay for the expected deaths and injuries. In one case, the jury awarded the plaintiff over $125 million. The judge reduced this award to $3.5 million, and the case was later settled out of court while on appeal. Another example is the 1985 case in New York, where a 72-year-old woman swallowed a pop-up thermometer in a turkey. The woman won the case because the thermometer was easy to swallow. The court ruled it was dangerously designed. Sometimes products can contain dangerous ingredients. In Maryland, a woman purchased a hair product that was advertised to give hair a shiny appearance. The day after using the product, she lit a cigarette and her hair caught fire. She was permanently scarred. The court determined that the manufacturer was liable because the chemicals in the product were absorbed into her hair and skin, causing them to be highly flammable. Another type of defect involves inadequate instructions or warnings about product use. This is one of the reasons why over-the-counter drugs and power tools come with so many warnings on packaging and even on the items themselves. While most injuries involve nothing but carelessness or bad luck, you'd be well advised to contact the Consumer Product Safety Commission if you think a product defect was even partly to blame for an injury to you or to a loved one. And if the injury was serious, you should also call a lawyer who is experienced in handling product liability cases. Remember to keep the product that caused your injury. In any future litigation, this will be an important piece of evidence to be analyzed by experts to determine exactly how the injury happened.
Let's talk for a minute about credit cards. Most people use them regularly. Sometimes we get lazy and trust the credit card company to charge us the right amount. But if there is a discrepancy in your bill, what can you do?
Suppose your monthly statement shows a charge you don't think you made, or you are being charged for merchandise that you have already returned. If you are like most of us, your first inclination is to call the bank or company about it. Sometimes that works, and you may find that your problem gets resolved. But in order to be sure that you'll get the protection offered by the Federal Fair Credit Billing Act, you must write the company that issued the credit card to challenge any errors on your statement. In your letter, be sure to include your name and account number, the date type, and dollar amount of the charge you are contesting, and why you think there was a mistake. It is helpful to make a photocopy of the bill and circle the charge in question. Don't send your original bill or receipts. Always make copies. Send your letter to the inquiries address given on the bill. That is usually different from the address where you mail payments, so don't enclose your letter with a payment or write on the invoice. It won't get to the right person. Your letter must be received within 60 days after the first bill containing the error was mailed to you. If you are close to the deadline, you may want to send your letter by certified mail, return receipt requested, so that you will have proof that you made your claim in time and that it was received. That is your responsibility in the matter. Now here is what the creditor must do once it receives your letter. It must acknowledge your letter in writing within 30 days unless the problem has been resolved. The credit card issuer must conduct a reasonable investigation and within 30 days either correct the mistake or explain why they feel the bill is correct. If you asked for proof of the charge in your letter, it must include documents showing the charge is correct, like a copy of a receipt with your signature on it. The creditor cannot close your account because of the dispute, but it can report to credit agencies that you have challenged a charge. While the bill is being disputed, you may withhold payment of the amount in question, including the affected portions of minimum payments and finance charges. You are still required to pay any amounts that aren't in dispute. If the bill turns out to have been mistaken, the creditor must remove all related late fees and finance charges. Of course, you will be responsible for those payments if the bill turns out to be correct. If you disagree with the creditor's decision about the dispute, write another letter to the creditor within 10 days and contact an attorney. There may be several courses of action available to you, and you will probably need professional help. You should also contact an attorney if the creditor doesn't follow the procedures outlined above.
Judge Wapner, what should I do if my credit cards are lost or stolen?
First, you should call your credit card company immediately and report what happened. You are not liable for any charges made after you notify the card company. Under federal law, you may be liable for up to $50 of fraudulent charges per card if these charges are made before you notify the issuer. For example, if you lose 3 credit cards, you may be liable for up to $150. To be safe, you should always keep a list of your credit cards and account numbers in a secure place separate from your cards.
What extra protection can I obtain against lost or stolen credit cards?
You may have heard about credit card protection plans. These plans can be viewed as a form of insurance against the unauthorized use of your credit cards. If you sign up with the plan, you give them the account numbers of all your credit cards. If your cards are lost or stolen at any time, you notify the protection plan representative, and he will notify your credit card company. You will be reimbursed for any unauthorized charges.
I received my credit card statement on Monday the 16th when I was out of town. When I came back on the 23rd, I found I'd failed to send in my payment in time. Because the credit card company asks me to pay every month by the 20th, I was assessed with a late charge. I wasn't given much time between receipt of my bill and the date on which it was due. Is this proper?
No. Federal law requires credit card companies to mail you your bill 14 days before it's due. In this case, it's clear that the bill wasn't sent in time, and you are not liable for any penalties.
For more information on the Fair Credit Billing Act, you might want to write for the free pamphlet entitled Fair Credit Billing. Mail your request to the Federal Trade Commission, Room 720, Washington, D.C., 20580. Are you someone who meekly nods fine when the waiter asks how the meal is, even if the soup was cold, the fish was overcooked, and the wine had turned to vinegar? Most of us would rather keep quiet about a problem than risk confrontation, rejection, or humiliation. That's unfortunate, because effective complaining helps everyone. The complainer feels better for having spoken up and may also get his problems resolved. The business gets feedback about its product or service and has a chance to keep a customer it was likely to lose. And society in general benefits from improved performance and happier citizens. For the final minutes of this tape, Judge Wapner is going to talk about the fine art of effective complaining.
Situations that cause complaints vary greatly. Tepid soup is one thing, faulty brake repair quite another. Effective complainers follow some common sense rules, even though they might not even be aware that the rules exist. Let's examine 10 of these rules.
Rule number 1 is, assume sellers want feedback. Smart merchants want to hear from their customers. Studies show that people who complain are more loyal customers than those who don't. Even customers whose complaints aren't always resolved to their satisfaction are more likely to buy again than those who suffer in silence.
Rule number 2 for effective complaining is, express yourself clearly and politely. Some people let themselves get so upset before they actually make a complaint that they don't communicate very well. Yelling or calling something a piece of junk may be emotionally satisfying, but it doesn't tell the seller very much except that you're angry. Being polite makes people more willing to help you.
Rule number 3 is, state the real problem. This seems self-evident, but it can be difficult. You're more likely to complain about the food if the waiter is obnoxious. You may be less happy with your purchase if you had to wait forever at the register to pay for it. Was the problem really what the plumber charged for the repair, or was it that he didn't clean up very well when he finished, or that he showed up late? Take the time to decide what the real problem is. Otherwise, you'll mislead the seller, and it'll be harder to satisfy you.
Rule number 4 is, decide what you want. The first thing good complaint handlers ask is, what can I do for you? Always decide what it is you want done. An exchange, a refund, a repair under warranty, a personal reprimand, whatever. If all you want to do is express an opinion or vent some anger, that's fine. Just realize that and tell the person you're complaining to that all you want is someone to listen. Few things are as frustrating as listening to a long complaint without knowing what response is wanted.
Rule number 5 for effective complaining is, assemble your evidence. Effective complainers are those who have their receipts, save the packaging, record serial numbers, and know the names of the people they've spoken with and when they spoke to them. They're the people who keep originals and mail copies.
Rule number 6 is, approach the right person. It's amazing how many people will complain to a government agency or write the company president without first contacting the salesperson they dealt with or the supervisor. As a rule, start with the person you originally dealt with. Move up the chain of command only when it becomes clear that the first person can't or won't get you satisfaction.
Rule number 7 is, be persistent. While a few companies drag things out deliberately, most will try to resolve complaints efficiently. Even so, some complaints do get lost, and a few will pose a genuine problem for the business so that it may take some time to decide. That's why you should be persistent, but also be patient and be reasonable.
Rule number 8 is, use the right tool for the job. Phone calls, letters, and visits all have their own advantages and disadvantages. Effective complainers calculate whether the precision and permanence of a letter is more important than the speed and informality of the telephone. They calculate whether a face-to-face visit will make it more difficult to refuse their request. In reality, a combination of methods is often needed.
Rule number 9 is, stay emotionally detached. It's natural to feel angry at being cheated, frustrated at being ignored, or humiliated at being rejected, but it's helpful to control those feelings as much as you can. While anger can give you the energy you need to fight, being angry can raise the cost of complaining to more than it's worth.
The 10th and final rule for effective complaining is, know your allies and when to use them. There aren't very many complaints that require a lawyer, a government agency, or the Better Business Bureau. Effective complainers know when outside help is useful and when it is a waste of time. The best way to use the Better Business Bureau is to check with them before you buy something major from a business you're doubtful about, not after you have a complaint. Consumer agencies are interested in unfair or deceptive practices. Contact them when you think your problem involves a pattern of dishonest or unfair treatment. Having a lawyer call or write for you can be very effective if enough money is involved to make a lawsuit seem like a real possibility.
The general information in this talk is not a substitute for legal advice from a lawyer. For specific advice based on your own individual circumstances, see the lawyer of your choice. You may want to listen to Judge Wapner's talk to you and your lawyer for assistance in selecting and working with an attorney.